Hearing comments with a request by lawyers for Mr. Mahama that some 12 questions should be answered by the Electoral Commission chairperson. The court, however, listened to legal arguments and came to the conclusion that it was not relevant. But first, we can take a listen to some of the arguments that were made in support of the request for those questions to be answered and the arguments against.
I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court.
Being sought are in the petitioner's own petition the answer filed by the first respondent and also the answer filed by the second respondent. Questions being asked of us that where did the regional coalition center pop up from is all in the law. That is why we are saying that everything is in the law before this court. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court.
A proposed interrogatory which does not relate to a matter mentioned in paragraph 8 of subgroup 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC.
Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
The court dismissed the application and lawyers for Mr. Mahama's team and the president's team have been reacting to the decision.
Indeed, just to let you know that we were ready and prepared with our issues because the last time the court directed that there was going to be a pre-trial, every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business.
Is your contention that
the real case in court has not started?
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth?
We didn't need to even, I think that Ms. Jikata eloquently dealt with the issue of relevance. By, for instance, taking the court through, step by step, the relevance of each of the questions that we wanted the Electoral Commission, to answer. And then also, when learned counsel for the first respondent was on his feet, he himself pointed out quite clearly that the issues we raised were contained in their answer.
So hearing of the matter continues on Tuesday, and the main business of the day is first and foremost that the memorandum of issues are to be filed by the parties in the case. This is simply a detail of what the parties opt or hold a view to be critical to the determination of this particular dispute, and so they are going to propose the questions that they think the court should be asking them to provide evidence to support, and once the court adopts that, then the trial proceeds from there. Reporting for Joy News from the Supreme Court, my name is Joseph Akable.